rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV150340, Bursch et al. Versus the Arizona Corporation Commission et al. Counsel, we are recording today's proceedings both by audio and video means, so when you step to the podium, if you would, please identify yourself and your client. Each side will have 20 minutes for argument, and counsel for the appellants is responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs. We've conferenced the case prior to argument. And so with those preliminaries out of the way, counsel, you may proceed.
Thank you, and good morning, Your Honor. Tim Sabo with Snell and Wilmer, appearing on behalf of the plaintiffs, Michael Bursch and David and Linda Wanzak. In this case, the government is seeking or arguing that there's no limit whatsoever to how deep into the past they can reach with administrative charges. This sweeping claim should be rejected. The court should impose some time limit, either through the borrowing of a statute of limitations or by looking to principles of due process. As the United States Supreme Court noted in Gabelli, statutes of limitation are vital to the welfare of our society and protect or promote justice.
Why isn't it enough to allow your client to argue under the statute that the ACC did not take action within a reasonable time?
Certainly, we would contend that the Commission has not acted within a reasonable time, Your Honor.
Isn't that a very fact-driven based analysis that's better presented to the Superior Court?
Your Honor, we certainly asked the Superior Court to look at those issues, and they decided not to take jurisdiction of the case. Our contention here is that either through due process or through borrowing of a statute of limitations, that this court can impose some time limit.
Well, go ahead and finish your. Go
ahead. You have discretion, of course, in terms of which statute is the most appropriate statute to borrow in terms of a time limitation that would make sense to this type of case and this type of proceeding.
I thought your argument, and maybe I misread it, was that the Superior Court basically, even though it said it wasn't taking jurisdiction, ruled on the merits. Is that just on the statute of limitations, or is that on the due process? So is it your position on the due process the trial court simply declined jurisdiction?
Your Honor, it's the minute entry there is a little curious because he does say I'm not taking jurisdiction, but then he does cite to Trimble and say no, there's not a statute of limitations. So it's a little hard to reconcile those two statements, but regardless, we did not have an opportunity to present any factual record to the Superior Court because this was decided on a motion to dismiss brought by the state.
Okay.
And, Your Honors, it's common, of course, for a court to borrow a statute of limitations when one does not directly apply, and that's because it is presumed that the legislature would want there to be some limitation that would apply to every action. The state's argument to the contrary rests on the Rigi rule, which is an outgrowth of sovereign immunity and principles of royal prerogative. But, Your Honors, Arizona courts have been moving away from those principles for over 50 years now, and it's time to put the nail in the coffin on those kind of arguments. And so, therefore, this court should reject the Rigi rule in this case. As to due process, Your Honors, I think it's helpful to kind of dig into a little bit of the specifics that we have, at least from the state's notice of opportunity, that will illustrate a little bit about the kind of prejudice that we're facing here. And, for example, the state is bringing what are called securities fraud charges under 1991, and some of the fraud charges are what are called disclosure charges. In other words, the state is saying, hey, you should have told the investor some things and you did not tell them those things. Well, of course, that's going to require litigation on what did we tell these investors from 1998 through 2008 when these investments were being offered. It's going to require documents, and we've provided an affidavit that the case files, the files for each of these clients no longer exist. And likewise, computers and emails from this time period, which is very long ago, simply don't exist anymore. So the evidence that you would need to dispute and litigate these issues is no longer around. And of course, memories have faded over the time period where, you know, I have a hard time remembering what happened last week, and we're talking about 1998 through 2008.
But you would agree you're not precluded from making those arguments under a reasonable time analysis?
As a due process argument, Your Honor, or?
Well, that's the only language I see from the statute, that they have to bring an action within a reasonable period of time. So why wouldn't that be an argument that you could make? And that would be, it would be better, seems like it would be a better forum. You could explain precisely what's missing or what's not missing, and why the length of time that the ACC took was somehow unreasonable.
Your Honor, which statute are you thinking of there?
44-2032.
And I apologize, Your Honor. I don't believe that we've briefed that one, and it's not springing to mind immediately.
Well, that's I think the rejoinder to your argument about borrowing a statute of limitations is that arguably under 44-2032, the legislature has already prescribed some limitation by saying within a reasonable period of time, the commission needs to act. So that relates both to your statute of limitations argument and also to the due process claim, it seems. Why isn't that the legislature's expression of its standard for commencing these actions?
Your Honor, certainly if there is a standard that's a reasonable time standard, certainly that's something that we're willing to explore. Our position is just that there should be some limit, whether it's 2004 or the criminal statute of limitations or this other statute or due process or latches or something. But our argument is that there must be some limit to how far into the past that the commission can reach. And the commission, of course, is arguing the contrary. They're arguing that there's no limit whatsoever, that they can go back 8 years and 10 years and 15 years and 20 years and 50 years, that there's no limit whatsoever to how far back they can go. And that's what we're asking this court to reject.
But you're asking, for example, the criminal statute. Presumably there are other interests that are implicated with criminal charges. Someone's liberties at stake. So presumably that statute might be shorter. It seems odd to have us just pull a statute of limitations out of the hat or adopt a particular statute when the legislature has chosen not to do that.
But conversely, Your Honor, the legislature has also not enacted a statute that says Corporation Commission, yes, reach back 50 years if you want to do that. So we're in a position here where there's not a express statute of limitation that applies, but also there's not an express exemption from a statute of limitations that applies. And Your Honors, returning then to the nature of the charges, in addition to the disclosure charges, there's also a fraud count that has to do with representations. And so this is an argument that certain representations were made to investors and those representations were incorrect. And again, this is going to rely, Your Honors, on evidence about what was said to the investors back from the period 1998 through 2008. And we have the same concerns about the memories are faded, the documents aren't available. It's just very, very difficult to litigate a claim that is that far into the past.
If there's an ongoing fraud, though, and let's say it started 20 years ago, but it's still ongoing today, are you saying that there would be a statute of limitations that would start only at the outset of the fraud?
No, Your Honor, that's not our contention. And typically, when you have at least in the criminal law context, where you have an ongoing series of violations, that you look at the last violation, not the first one, as I understand it, anyway. And what we're saying here, and what the division is alleging here, is that this conduct, even under their allegations, ended in 2008. So we've got a big gap here between the last alleged sale and now the filing of these charges in 2014. And likewise, Your Honor, there's also an allegation of fraud regarding the use of the term investor relations office. And again, that our defense on that is going to rest on conversations between my clients and Concordia back in the 1990s, as well as emails and documents from that time period that simply don't exist anymore. So there are serious due process concerns with prosecuting a case this old. And the Commission, in its procedural order that was issued by the administrative law judge, dismissed those kind of concerns because the Commission felt that, well, this is a documents case. We can just litigate this case on the documents. But in reality, a lot of these issues are going to rely on memories, and on documents and emails and things that simply don't exist anymore because of how old the case is. Your Honor, in addition, we've got the whole issue of are these things securities? And our defense on that, the state has to prove under the Howey test that there's a commonality of interest, as well as that there was a expectation of profit from others. And when the administrative law judge analyzed these issues in his procedural order, he really looked and relied on the allegations in the notice of opportunity in terms of not so much how the agreements were written, but how they operated in practice in order to survive that challenge on the motion to dismiss. But again, so now we're going to have to litigate issues about it, not what do the documents say, but how things were done in practice in this California entity from 1998. And that's a very difficult thing to do at this late date, Your Honors. Your Honor, to address briefly the discovery rule issue, and the state brought that up in their answering brief. And it's certainly our contention that the discovery rule has been waived because it was not raised in the Corporation Commission. It was not raised before the Superior Court. So the first time we're seeing this argument is in the state's answering brief. In addition, the discovery rule does not apply to the registration violations. That would only apply to the fraud violations, and that's consistent with the common law origins of the discovery rule. And as the Supreme Court noted in the Gabelli case, it's generally inappropriate to allow the government to invoke the discovery rule in an enforcement case because it's the government's job to go out, seek out, and find wrongdoing. The discovery rule is intended to protect the innocent party who's out there who has been harmed by fraud and was not able to find out about the fraud, and so therefore it wouldn't be fair to bar their litigation due to a statute of limitations, and that's a very different context than what we have here. And Judge Catani, to your earlier question about the seriousness of criminal charges, and obviously they are very serious indeed, but these are very serious charges as well, even though they're being brought in an administrative proceeding. The consequences are extremely grave. We're talking about having a finding of fraud potentially made onto these people, as well as very serious financial consequences. The state is seeking a judgment of over $8 million, which is a whole lot of money. And due to the way bankruptcy law works, that's not going to be dischargeable. So that will be an $8 million judgment sort of hanging over their head for the rest of their lives. So that's a very serious consequence. And, Your Honor, we would draw a distinction as well between prospective remedies and retrospective remedies. You know, if the state wants to ask us to or order us not to make any sales of securities anymore, I mean, that would be fine with us. That's a prospective remedy. If the state wanted to have a receivership, we would not oppose that. That's a prospective remedy. What we're talking about is retrospective remedies where the state is trying to impose damages and financial penalties on our clients. And, Your Honor, I'd be happy to answer any other questions that you have. If there are none, I'd like to reserve the remainder of my time.
Thank you.
Thank you.
Mr. Burgess?
May it please the Court, Jamie Burgess representing the State of Arizona, the Arizona Corporation Commission, and the Director of the Securities Division, Matthew Newbert. This case arises because two CPAs in Lake Havasu City sold investment contracts to many of their accounting clients over a 10-year period. Because they didn't register the securities, they stayed off the radar screen of the Commission. The Commission doesn't have a crystal ball. It can't be monitoring private transactions occurring all over the state. That is not our charge. That is not our mission. The mission, part of the mission of the Securities Division is to, when we learn of complaints, investigate and, when appropriate, bring enforcement actions to, under Judge Catani, you referenced ARS 44-2032. That statute specifically directs the Securities Division to seek an order requiring the respondents to correct the conditions resulting from their violations of the Act. And it requires, I want to address your observation that statute contains language about doing so within a reasonable time. Respectfully, the parties didn't brief that statute because it doesn't apply in that context. Rather, the language of 2032 provides that we can seek an order requiring the respondents within a reasonable time to correct the conditions resulting from the Act. And that will include seeking restitution for the investors who've lost their money. In this case, $3 million. 58 investors lost over $3 million, while the respondents made $3 million in custodial fees and undisclosed commissions that were paid to them.
I'm sorry, counsel. So you're saying 44-2032 doesn't apply at all?
No, that is the statute that authorizes us to bring the action that we have brought. What I'm saying is the language about acting within a reasonable time. It's that the order that we're to seek will require the respondents to correct the conditions resulting from the violation within a reasonable time.
So that doesn't impose any sort of implicit reasonableness standard in terms of the statute of limitations? Or
no, it doesn't, Your Honor. And I want to address something else that Mr. Sabo said that is just simply wrong. Mr. Sabo said in his opening that the legislature has not said the Arizona Corporation Commission can reach back 50 years. In fact, he's mistaken. ARS Section 2041, which was renumbered in 1986, it was originally part of the 1951 Act, and Section 2041 is still on the books, and it says that the division can enforce violations that occurred before the enactment of the current Securities Act in 1951. Now, that provision was renumbered into what's currently 44-2041 in 1986, which was 35 years after the Securities Act was enacted. So implicitly, the legislature in 1986 approved of going back 35 years in an enforcement action. That statute is still on the books. Again, it's ARS 2041. And now, granted, the Securities Division would have some practical difficulties proving a case with conduct that old, and it's not our practice to do so. This is an unusual case because the conduct was ongoing for so long, and because they didn't register, the Commission was unaware of their conduct. When we learned of the conduct, we did bring an enforcement action, and that's the subject of today's proceeding. Yes, yes, Judge Kessler.
I may have missed it, but I don't see where you cited that statute in your briefs.
No, we didn't, Your Honor. It was not cited in our briefs.
Okay.
In your view, is there any limitation whatsoever on how far back you can go?
There is a practical limitation, which is we would have a hard time, depending on the age of the claims, going back 50 years or 35 years or to adjudicate conduct that occurred that far back. But in terms of the plain language of the statute, Your Honor, no, the legislature has not seen fit to impose any statute of limitations on how far back an enforcement action can go. And that's consistent with the idea, which is set forth in the preamble and the statement of legislative intent of the Act, that the Act be remedial, and that's why in Section 2032, the order we seek is not necessarily punitive. Rather, it is to correct the conditions resulting from the Act. That is the language of 2032, and that is remedial. And it is not unusual for, in fact, the common law, the default under the common law rule, and this is in the Tucson Unified School District case, is that unless, and it's also in the City of Bisbee case, 2 Arizona Supreme Court cases, which both hold that under the common law, there is no statute of limitations that applies against the state. And the reason for that is not because we're the sovereign. It is because the rights that we seek to enforce, the rights that government agencies seek to enforce, are those to protect the public, and they belong to the public, and so the legislature has not seen fit in civil enforcement actions to impose a statute of limitations against the government, and you can see that in the United States versus Ag Bank case, which was an IRS proceeding where the district court here in Phoenix refused to borrow a statute of limitations. You can see that in the United States versus Jack Tory case, which was a customs duties case where the Federal Circuit Court refused to borrow a statute of limitations, and it held that under the common law, both at the federal level, and it's also true for the states, and it's certainly in Arizona. We've got Arizona Supreme Court cases approving of Trimble's enunciation of the rule, which is that unless the legislature has expressly declared that a statute of limitations should apply against the government, the courts will not recognize, they will not borrow, they will not impose a statute of limitation against the state.
Assuming there is not a statute of limitation, is there anything that would prevent the parties from alleging that in this case the length of time that they waited to bring an action was simply unreasonable, in that the evidence is, because we're unable to bring in evidence that we could have presented had this been brought earlier, are they precluded from ever making any kind of equitable argument like that?
No, they are not, Your Honor, because they have a due process claim, but the due process claim or the laches claim or the estoppel claim would involve unreasonable delay. In fact, due process would require intentional delay by the government. Same with laches and estoppel would require unreasonable delay. And you'll see that in some of the cases that they have cited, but those cases, the Tucson Electric Power case, the Valencia Power case, the State versus Garcia, which was an child support arrearage case. In those cases, the government unreasonably delayed. In 2 of those cases, I want to point out, it's a very important distinction. In Tucson Electric Power and in the Valencia Energy case, the parties, the the citizens, the taxpayers in those cases affirmatively went to the Department of Revenue and said, hey, we want guidance. We're going to enter into this transaction or seek this deduction for these reasons. Will you approve? And in both instances, the government approved, and then 5-6 years down the road changed their minds and assessed back taxes. That is so different than what happened here, where these two CPAs did not register, didn't seek any guidance from the commission. We don't know, because the record hasn't been developed yet, whether they sought even legal counsel. They just went off and started selling these investment contracts to many of their accounting clients. And so in contrast to the parties that in Valencia and in the Tucson Power case, they stayed very much off the radar. They didn't seek any guidance. And so to answer, I'll try to wrap this, answer your question up. Yes, there is a remedy for a litigant who can establish that the government knew about the conduct and then unreasonably delayed or intentionally delayed in order to gain some kind of a tactical advantage. There is no evidence in the record of anything like that here. There is no evidence in the record of when the Securities Division received a complaint about the appellant's activities. There is no evidence in the record of they have not. There's no evidence in the record. Mr. Sabos talked at length about lost documents and witnesses who are no longer available. There is not any evidence in the record of a specific individual who's no longer available to testify. There is no evidence in the record of
because of where we are at this stage of the litigation.
Exactly, Your Honor. It hasn't been developed yet.
And the only point being that to the extent there is that type of argument, it would have to be developed presumably during the trial. If there is some argument regarding an inability to defend the case, it would not be at this stage of the litigation.
That's exactly right, Your Honor. It would be wholly inappropriate for this court or any court to impose a statute of limitations where the legislature has expressly not done so. The legislature knows how to impose a statute of limitations against the Securities Division and has done so. It did so in the 2000 amendments to the Securities Act. In particular, I believe it's Section 1962, which is in Article 10 of the Securities Act, which requires the Securities Division to bring an action to revoke a salesman or a dealer's license within 2 years after the dealer or salesman has allowed his registration with FINRA, or in the case of a salesman, the broker allowed the registration with the broker-dealer to lapse. So the legislature in 2000 imposed a statute of limitations for revocation actions. It has never, Trimble was decided in 1986. The legislature has amended Section 44-2004, which contains those statute of limitations for civil actions. The legislature has amended that statute 3 times. It has never seen fit to change the result in Trimble. And that is, again, consistent with the remedial purpose of the Securities Act that, and frankly, the problems with trying to impose a statute on cases and investigations in cases like this, where there is a very long fuse. I mean, Your Honor brought up a very good example of a fraud that continues for 20 years. Bernie Madoff comes to mind. These types of cases and other types of fraud cases, consumer fraud cases, non-criminal. There is no statute of limitations because the legislature has made a policy decision and balanced the interests between granting the litigants at issue, the defendants, if you will, some period where at some point in time the ability to know that their conduct is no longer going to render them liable, versus the public's interest in addressing rights that belong to the public. And the legislature makes those decisions. It is for the legislature to enact a statute of limitations. It is, Your Honor was exactly correct when you said it would be quite odd to pull a statute of limitations out of the hat and impose it. The legislature is the body that imposes statutes of limitation. That's why they're called statutes. They're enacted by the legislature. This court is to interpret the law as written, and as written, the plain text of the Securities Act does not impose. It imposes a statute of limitations against private litigants in Article 14. It does not impose a statute of limitations against enforcement actions in Article 16. Again, that's consistent with the remedial purpose of the Act and the protection of the public. The legislature has made that judgment. This court should not disturb it. I just want to address briefly Mr. Szabo's argument that somehow the discovery rule was waived. The appellants want to have their cake and eat it, too. They asked this court to apply either 44-2004 or ARS 13-107, which is the criminal statute of limitations for most felonies. Both of those statutes contain discovery rule language. The reason we didn't waive it is because neither one of those statutes applied, and the administrative law judge correctly found that neither one of those statutes applied in this context, and so there was no reason to address the discovery rule language. But if this court were to disagree and find that it should borrow one of those two statutes, it would and remand. You'd have to remand because there's a discovery rule issue of which is not developed at all in the record, which is when did the Securities Division learn of appellant's conduct, and did it act, or when should it have reasonably discovered appellant's conduct? That is not developed in this record at all. And so if you're going to apply one of those two statutes, which you shouldn't do, but I want to address Mr. Szabo's point, he can't have his cake and eat it too. He can't have you apply one of those statutes and then not have you apply the discovery rule language, which would require a remand. With respect to his argument about Gabelli and the Supreme Court case, that Supreme Court case was interpreting a completely different federal statute. It's 28 Section 2462. It is a general statute of limitations in the federal system that applies to any. It's not security specific. It applies to any federal administrative action that seeks to impose a penalty, a fine, or a forfeiture. That statute does not, by the way, bar the SEC from bringing an enforcement action seeking equitable relief, such as disgorgement, and the SEC versus Reardon case and the SEC versus Wiley case, which are cited in our briefs, make that clear. And those are recent federal appellate court or cases. So there is no statute of limitations that applies against the SEC, except when it seeks to impose a penalty or a forfeiture or a fine. And so appellant's argument about Gabelli and the federal statute, it's a completely different statute. It doesn't apply here at all, and the court should not use it as any kind of an analogy for what it should do here. Unless the court has any questions, thank you very much for your time, Your Honors.
Thank you. And rebuttal, Mr. Szabo?
Yes, Your Honor, thank you. A few quick points. As I understood Mr. Burgess's argument, he is now conceding that some type of laches claim can be brought against the state and that the state is subject to that. I will note that that was not the ruling of the administrative law judge. His ruling, this is page 177 of our appendix at line 11, says generally equitable defenses such as estoppel and laches do not apply against the state or its agencies in matters affecting governmental or sovereign functions. So the administrative law judge said, no, just flat out, you can't have laches, you can't have equitable estoppel. These kind of arguments, we're not going to permit them. So at least, given counsel's argument, at least on that point, the commission should be reversed.
I didn't hear it quite the same way. I heard him lump together the doctrines of laches, equitable estoppel, and due process, saying whatever you call it, essentially, there could, at its outer reaches, be a claim. Moreover, we've got lines of cases as a matter of law regarding laches against the state, so I wouldn't hang your hat too heavily on that one.
All right, Your Honor. The counsel also referred to the plaintiffs being, quote, off the radar, and his argument was by not registering, that should in essence, extend the statute of limitations. A couple of responses to that. First, obviously, you're only required to register if it's a security, and that's the issue we're disputing somewhat vociferously. And secondly, it's the job of the commission to seek out violations, including registration violations. And thirdly, they did, in fact, discover this violation at some point, as shown by the fact that they brought the case, even though the securities were never registered. Your Honor, Mr. Burgess referenced the Tucson Unified School District case as well as the City of Bisbee case. Both of those cases involved an express statute of limitations, in both cases 12-510 or its predecessor in the revised statutes applied directly. And so while the courts may have discussed the common law basis of that statute, those cases were expressly relied on the express exemption from the statute of limitations in 12-510.
Well, what's your best argument for why we should not apply Trimble in this case, particularly given that the legislature has not chosen to do anything inconsistent with Trimble?
Your Honor, I think the legislature would be agog if they thought that the state could reach out with administrative charges going back 18 years and 25 years and 50 years into the past and have this kind of liability hanging over all the businesses in the state of Arizona, given all the different regulatory agencies that exist and could bring enforcement actions. So I would disagree, of course, that the legislature has endorsed that, and it would be our view that the RIGI rule, and Trimble is the only case in Arizona that relied on the RIGI rule without also having an express exemption, a statutory exemption applying, that the RIGI rule is outdated and ought to be overruled. Your Honor, Mr. Burgess brought up Bernie Madoff. I'm going to distinguish Bernie Madoff. This is not a Ponzi scheme. It's not a pyramid scheme, as was the case in Trimble. It was not an ongoing fraud of any kind. This is a case involving real loans to real truck drivers driving real trucks secured by real titles to those trucks. So this is the opposite of Bernie Madoff, which was all a fraud and a fiction. These are real investments, and the plaintiffs thought that they were doing things appropriately and in compliance with the law, and now all these years later.
The claim is very different from whether a statute of limitations should apply, is it not?
I'm sorry, Your Honor.
The merits of the claims are very different than whether a statute of limitations should be applied.
Certainly, Your Honor. But the Trimble case, where you did have a pyramid scheme, that kind of called out for at least some type of receivership to take over the assets and wind them down and pay them out to the investors, and that's not simply the case here. Thank you, Your Honor.
Thank you. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. And at this time, the court will stand in recess pending our next argument. Thank you.